The Honorable, the Supreme Court.
Good afternoon, everybody. Thanks very much. Please be seated. And when you're ready with the live stream, please call the case.
Good afternoon, Your Honors. The matter before the court this afternoon is the case entitled In Re Joseph Bruyette, case number 25 AP 057. Representing the appellant, Joseph Bruyette, is Attorney Brianna T. Hauser. Seated at counsel table with Attorney Brianna T. Hauser is Attorney Anthony Don. Representing the appellee, the state of Vermont, is Attorney Arthur Brown. Seated at counsel table with Attorney Arthur Brown is Attorney Zachary Chen.
Okay, thanks very much. Good morning. Good morning. Good afternoon, counsel. Nice to see you all. And we'll start obviously with the appellant. Please come on up, counsel. You all splitting time? Is the appellee? No. You are? No. No. Okay, so before you start with your argument, please introduce yourself and your client.
Good afternoon, Your Honor. May it please the court, Brianna Hauser on behalf of appellant Joseph Bruyette. The PCR court made multiple errors warranting reversal of the denial of Mr. Bruyette's petition for post-conviction relief. First, the court erred in denying the petition on the merits, and second, the court erred in denying the petition on the alternative procedural basis. On the merits, Mr. Bruyette had the burden of proving the two prongs of the Strickland standard. First, that his counsel's performance fell below the standard for a reasonably competent attorney. And Mr. Bruyette did this by having attorney Dan Albert as an expert testify that counsel's performance fell below the standard for a reasonably competent attorney. The state had no expert to contradict that testimony.
Does that mean the court has to accept it in your view?
It doesn't mean that, but in this case, Attorney Albert's testimony was based on the record, and that was that his opinion was that counsel's performance fell below the standard of care because he failed to present a sentencing memo. He really didn't mount any sort of mitigation case on behalf of Mr. Bruyette, and he didn't present any witnesses. And that's like in Ray Williams, where this court affirmed a determination that counsel's performance at sentencing was deficient for those same reasons. And so the job of the sentencing attorney is to humanize the client. And in this case, that just didn't happen. There was ample evidence in the pre-sentence investigation report about Mr. Bruyette's background that his sentencing attorney didn't even refer to.
Well, he did. I mean, the defense attorney, at least according to my notes, succeeded in striking the PSI's reference to a vacated armed robbery conviction and for and other things as well. So it wasn't totally without substance.
It wasn't, and I mean, there would be a different standard if we were saying that counsel did nothing at sentencing. But what we're saying in this case is that what he did do simply was not enough to provide effective assistance of counsel. The PSI indicated that Mr. Bruyette had first been in juvenile court at age 15, that he had repeated probation supervision as a teenager. He had a severe drug problem by the time he was as early as 19. And then in 1982, by the time he was 22, the PSI indicates that he had no problems with staff at the correctional facility, that he appeared to show an interest in turning his life around. He completed his GED. Later, when he was brought back in, he was subject to a physical attack by other inmates that required 55 stitches. He was placed in protective custody. He had been at the week school for several months, and that was beginning in 8th grade. After that, he never went back to a normal school. And so the sentencing court's conclusion, based on the very little that sentencing counsel had provided, was essentially that Mr. Bruyette came from a normal upbringing and just became this monster. And that just plainly wasn't true. And it was, there's no dispute that this was a very serious offense. But that was why it was all the more important for sentencing counsel to present some mitigation evidence on behalf of Mr. Bruyette to humanize him, to convince the court to give him a sentence that reflected him as a whole person, aside from just the offense that he had committed.
What mitigation evidence should have been presented that wasn't?
So the information in the PSI certainly should have been explored and highlighted by sentencing counsel, in addition to the evidence, the testimony of Ms. Berry that was presented at the PCR hearing. That was just an indication of what information would have been available to him. But this court hasn't required that a petitioner prove what evidence would have been presented at the sentencing hearing. In Ray Williams, the petitioner never established what information would have been presented if he were given a new sentencing hearing. And this court nonetheless held that counsel's performance was deficient.
So that leads me then to my question, Attorney Hauser. I find, as a former criminal defense attorney, I find this attorney's performance woefully inadequate. But how do I find prejudice? I can't, I'm having a hard time satisfying the second prong of Strickland.
So the standard for prejudice is that there's a reasonable probability that but for counsel's errors, the outcome would have been different. And the United States Supreme Court has acknowledged that ineffective assistance of sentencing counsel can establish the prejudice prong because any amount of additional jail time has Sixth Amendment significance. So we're talking about, in Mr. Bruyette's case, he was sentenced to 45 to 85 years. The 85 years was the maximum allowable sentence he could have been given. And so his sentencing counsel not having presented any mitigation evidence in this case, had he done so, there is certainly at least a reasonable probability that he could have had a lesser sentence than that. And that means, even a 40 to 60 year sentence, that this sentence was imposed when Mr. Bruyette was 30 years old. So having 85 years at the top end was effectively a life sentence.
But is he going to serve the max? We don't know that. He could get out at his minute.
So it's not in the record. Mr. Bruyette has been released on parole. So we're only talking about the top end of this. And so if his maximum sentence were reduced, he would at least have the opportunity, by the time he's 80, to live a life not on supervision. And certainly if sentencing counsel had presented some mitigation evidence, it could have made a difference. If there are no additional questions on the merits, I'll move on to the procedural issue. And first, just to put this in context, it makes no sense for a court to deny a claim on procedural grounds where it did at this state. In this case, it had already been litigated for 6 years. It had gone to a full merits hearing. There were multiple attorneys involved. There is no good reason for denying it on procedural grounds when it could have reached the merits. And in fact, it did. But it's important because the court in this case applied a doctrine that this court has acknowledged does not apply in PCR cases. And so we're talking about 3 different doctrines here that are at play. There's claim preclusion, abuse of the writ, and successive petitions. And none of those apply in this case. Claim preclusion, again, as this court has acknowledged, does not apply to PCR cases. And this court has said that's because conventional notions of finality of litigation have no place where life or liberty is at stake and infringement of constitutional rights is alleged. And so in this case, the PCR court applied claim preclusion in this case, and that was just wrong because it doesn't apply. Abuse of the writ applies where a petitioner raises a claim that's not been previously raised, and the state has the burden to plead abuse of the writ. It didn't do so here. It never moved to dismiss the claim as an abuse of the writ, and so that doesn't apply. The third doctrine.
Well, I'm sorry. So Attorney Hauser, maybe I'm wrong procedurally. The 2014 PCR, that was an abuse of writ analysis. And wasn't that on the merits because the petitioner did not fulfill his burden in the motion for summary judgment, it isn't that on the merits?
So,
Under, excuse me, under Chandler.
well, two things. I mean, one, the 2014, my understanding of the record is the 2014 PCR, there was a motion to dismiss based on the evidence, but what the court's order actually was that it was an abuse of the writ because Mr. Bruyette had not established cause for not having raised this claim prior. So I don't believe there was a determination on the merits even at a summary judgment stage. But even if there was, for successive petitions, this court has adopted the framework from Sanders, and that requires an ends of justice analysis. And in this case, there's no reasonable argument that the ends of justice would not be served by reaching the merits in a case that has gone to a full merits hearing and that the court can decide on the merits. Without the ends of justice test, if a trial court just looks to whether a claim was previously decided, it's effectively just applying claim preclusion. So
Sorry to interrupt. Do you agree that it's the same or a similar claim, the one that we're here on today, as the one that Justice Waples just referenced?
yes, the claim in the 2014 PCR was ineffective assistance of sentencing counsel. And it was the same claim that was raised in the 2018 petition that was actually brought while the 2014 petition was pending. It was the same judge who was involved in both of these cases. And after dismissing the 2014 PCR as an abuse of the writ, it allowed this 2018 PCR to proceed. And
How is that not a successive petition? If it's the same claim and it was dismissed?
so it
The previous one was summary judgment. Let me try to be more precise. It was resolved, right, with prejudice? And so how is it a different claim that we're on now here today?
Well, we're not saying it's a different claim. We're saying that where a successive petition is presented to a PCR court, the court has to apply the analysis from Sanders that it's adopted. And that analysis requires that the court do an ends of justice analysis. And that is, the court has to ask itself whether the ends of justice would be served by reaching the merits of this successive petition. And that didn't happen in this case. The PCR court in this case never considered whether the ends of justice would not be served by reaching the merits. And
Because they relied on claim preclusion.
right, but
No, I understand.
Yeah.
They never reached, the judge never reached the ends of justice argument because he was relying on claim preclusion.
yes, exactly. Yes. And if there are no further questions, I'll reserve the remainder of my time.
Okay, thanks very much. We'll hear from counsel for the appellee, please. And if you would, start by introducing yourself and your client.
Yes, Your Honor. Good afternoon. My name is Arthur Brown, and I represent the appellee, the state of Vermont. So I hope to address what I view as the two most important issues to emerge from briefing, and I'll take them in the opposite order they were just taken. As I frame those issues, they are that Section 7134 directly bars this PCR case, and that there is not sufficient mitigation evidence to warrant relief. So first, Section 7134. Vermont courts have already considered Mr. Bruyette's case many, many times. In his prior sixth PCR motion, the courts considered exactly the same claim that they're asked to consider today. That claim is now raised again in his seventh PCR motion. Given the prior adjudication on the merits, the lower court properly ruled that 13 VSA Section 7134 gives a sufficient basis on its own to dispose of this case without considering the merits.
Is the prior adjudication on the merits, are you speaking to the dismissal with prejudice by Judge Hoare on the 2014 petition?
I am, Your Honor. Yes, that was a dismissal with prejudice after a ruling on a summary judgment motion. That was a prejudicial ruling. I want to break this issue down into 3 points. I want to first talk about some terminology. Then I want to talk about an ed pedeference case cited in an appellant's reply brief that gave me pause. And then last, I want to talk about the ends of justice factor. So regarding terminology, appellant articulates on page 10 in footnote 3 of his reply brief that the state seeks to muddy the distinction here between section 7134 and res judicata. And I think it was clear from what I just heard that that appellant believes there's also a distinction between section 7134 and claim preclusion. The state's position is that there is no distinction between those terms. We can debate how res judicata, also called claim preclusion, applies in the PCR context, but the fact that it applies at all is due solely to this statute. Traditionally, res judicata did not apply. It does now apply in a form because of section 7134. So the state's position is that when I'm referencing these three terms, I'm referencing the same legal phenomenon. The statutory language supports that conclusion. That the statute 7134 reads that a court is not required to entertain a second or successive motion for similar relief on behalf of the same prisoner. That statutory language is a description of res judicata or claim preclusion.
If that's true, what's the point of the abuse of the writ doctrine?
This court explained that or answered that question in INRI laws. So a direct bar, what I'm calling a direct bar or claim preclusion or res judicata, only applies to a same claim raised again, whereas abuse of a writ applies to a different claim that could have been raised but wasn't. So that type of different claim wouldn't be claim precluded. It wouldn't be directly barred by 7134. But INRI laws, this court explained that there's a binary analysis. And so for new PCR claims previously withheld, there's screening for abuse of the writ, which I'm not going to go into here because it just doesn't matter in this case. It mattered in the 2014 case, but it doesn't matter here. What matters here is that the same PCR claim previously adjudicated and then raised again is directly barred by 7134. One way to refer to that phenomenon is claim preclusion.
Well, why isn't that successive petitions?
I'm sorry, Your Honor.
So why isn't that successive petition?
So why isn't this a successive petition?
Yeah, what you just described, why is that not a successive petition?
It is a successive. That's
Oh, it
another
is.
way to
You're
refer
saying
to
it is. Okay.
Yes.
Okay.
These are
I
all,
thought you said it wasn't. Okay.
the language of res judicata. Res judicata is a common law term.
Right.
And so there are many layers of terminology. Over time, I think the second restatement of judgment has moved toward terms like claim preclusion or merger or bar. And then here we have an added layer of terminology because we're in the habeas land where traditionally that did not apply, but it now does by virtue of statute. So in the federal world, we talk about, EDPA, separate statute, which has separate terminology. Here, we're in the context of Vermont's law, 13 VSA 7134. So right, I think it's fair to say, judging from the statutory language, that this is a second or successive motion.
I'm agreeing with you.
Oh,
Attorney
okay,
Brown.
sorry, I apologize.
But thank you.
On the issue of
I wanna
prejudice,
just follow up on that. So are
Sure.
you using those terms interchangeably, res judicata and successive petition?
I am, Your Honor, with the caveat that I would not apply those terms to a new claim that was previously withheld, but is now raised. I wouldn't say that for that claim, I'd use abuse of the writ.
Use of writ, okay.
But same claims, res judicata, claim preclusion, 7134, successive. I think those terminologies are all getting at the same
So when
thing.
you say a straight 7134, or when you say claim preclusion, you're also talking about a successive petition?
Well-
You're using that in a similar way?
I think I don't like that term because I'm not referring to simply a numerically successive motion or petition. What I'm referring to is a successive presentation of the same claim. So if the petition just consists of claims already adjudicated, then yes, it's a successive petition. But if it just refers to a numerically successive petition, meaning a second petition, but one that raises claims not presented before, now we're in abuse of the writ jurisdiction. I do want to direct the court's attention to two Section 2255 cases that directly support the conclusion that a ruling for abuse of the writ is an adjudication on the merits. Those cases are cited on page 23 of the state's brief. They are Arnault versus Marbury, a 2009 Seventh Circuit decision, Ahmed versus Warden, FCI Inglewood, that's a 2002 10th Circuit opinion. They're both, again, both 2255 cases. I do want to take a moment to address an AEDPA deference case, meaning a Section 2254 case cited in appellant's reply brief because it gave me some pause. That case is Thomas v. Horn, a 2009 Third Circuit case. I raise this point simply to note that there can be no preclusion when a federal habeas court sits in review of a state criminal judgment. That was settled long ago by the U.S. Supreme Court in cases like Brown v. Allen in 1953. The federal courts just have an overriding interest in ensuring uniformity of and obedience to the federal Constitution. So that's an overriding paramount interest. And there just is no res judicata or claim preclusion in that context where you have two sovereigns and the federal sovereign reviewing the state sovereign's court. That's the 2254 context. It doesn't give guidance here because there just can never be preclusion in that context. So cases like Thomas v. Horn and other 225 cases give no guidance here. For guidance, the court should look to how the federal courts interpret or give preclusive effect to their own judgments and rulings. And again, that's the 2255 context. Briefly, I'd like to address the factors of ends of justice. That is a factor. The court adopted that factor as one of three in re-laws. The factor was taken from the U.S. Supreme Court's decision in Sanders. At times, and I'm referring specifically here to the case of In re Town, the court has considered whether that factor still applies. I just want to be clear. It's the state's factor that factor, the ends of justice factor, does still apply. This court has not abandoned the Sanders test.
So, Attorney Brown, In re Town does not go into great detail, though, as to the application of the ends of justice. So you're asking this court to take that into consideration, but if I follow the logic of Town, setting out the distinction between abusive writs and successive petitions, I almost read that to say that you don't need to reach that issue of ends of justice or interests of justice. Is that wrong?
The PCR court reached the issue, and this court, in my view, would need to reach the issue. That factor is bound up in whether a claim is precluded, meaning directly barred under 7134. So I think the court would need to reach that factor.
Even though Town didn't go into terrific detail about that.
I think what Town held is that whether they considered the factor or not, the result would be the same.
Right, exactly. Okay, I see what you're saying. Great, thank you.
So ends of justice traditionally means either prior evidentiary ruling was not full and fair, meaning there was something defective about the hearing, or it wasn't able to operate correctly because there was important undiscovered evidence, or it can mean that there's some sort of new retroactive law that warrants relief. That factor isn't met here. So the interests of justice do not support reopening the merits here. I will note the PCR court did not invoke the magic words ends of justice in its opinion, but its rationale was articulated. That's found on printed case page 9. It's the next to last paragraph of the court's opinion. The court mentioned that claim preclusion doesn't normally apply here. And then it noted that Mr. Bruyette's claim had already been found to be abusive, meaning the 6th PCR court found that appellant could and should have raised this claim in one of his still earlier PCR motions. So the facts here are not new or not newly discovered. The Weeks report was clearly referenced in the PSI, and Mr. Bruyette's childhood hasn't changed since his childhood. It's been known to him for decades. So the evidentiary process that was afforded to Mr. Bruyette, it was full and fair, and the ends of justice do not warrant reopening. I'll note finally that this court has considered ends of justice in an abbreviated fashion. It did so in re-laws in a paragraph 23. It mentioned that a double jeopardy claim was barred. There was no mention of ends of justice, but the court presumably took cognizance of that account. Similarly, in Woodmonsey, the court just noted in a sentence that ends of justice didn't warrant reopening here. There wasn't really an articulated rationale, but the court was considering it. This court was considering it, and the PCR court considered it. I now want to move, with the time I have left, to the ineffective assistance of counsel claim. The state's strongest point here is that appellant has not produced meaningful mitigation evidence in this case. There is a stark contrast between the cases on which appellant relies and the measure of evidence in those cases and the evidence available here. So I'll just run through the cases. This court granted relief in Henry Williams after a PCR court held a 12-day merits hearing. Similarly, in U.S. Supreme Courts like Williams v. Taylor, Wiggins v. Smith, and Porter v. McCollum, there were multi-day hearings and voluminous records. Those are quotes taken from those decisions. By contrast, the PCR hearing in this case lasted for less than an hour and a half. Specifically, it lasted from 9:49 to 11:10 a.m. There just was not a lot of evidence presented here to the PCR court. And it's the state's position that the evidence presented does not warrant relief. I will not dwell on the Weeks report, what the parties have called the Weeks report, but it's a 6-page document that addresses 150 years of abuse at a juvenile detention facility. It doesn't mention Mr. Bruyette. The state's position, as it doesn't have a sufficiently probative connection to him to matter in this case. I will address the testimony of psychotherapist Crystal Berry. That testimony spans only 11 transcript pages. Those pages are at Appellate Volume 1, pages 64 to 74. On my review, Ms. Berry testified that Appellant Bruyette told her that Appellant Bruyette said he was electrocuted at 9 months old. He had speech therapy classes at 4 years old. He saw a friend drown at age 9, and he saw his father struck by a motor vehicle, causing disability, also at age 9. There are two problems with Ms. Berry's testimony. The first and most serious problem is that the PSI indicates Joseph Bruyette had a supportive family and a good home life and a good upbringing. The PSI indicates that when he was not incarcerated, and there was a period of incarceration as early as the late 1970s, but when he was not incarcerated, Joseph Bruyette lived at home with his family until December of 1982, when he was 23 years old. Similarly, in a section titled Home Environment, the PSI says of Mr. Bruyette, this young man, and this is a quote from the PSI, this young man was brought up in a good family situation in the village of Swanton. His parents have always done what they felt was best for their family, but Joe has been a source of frustration and embarrassment for him. From various reports and observations, it appears that Joe has been overprotected, particularly against the consequences of his misconduct. So again, this isn't like the case of Wiggins v. Smith, where a defendant was shuttled from foster home to foster home. It's not like Williams v. Taylor, where a defendant's childhood was filled with abuse and privation. And I will note for the court that Attorney Kershaw did seek to humanize Mr. Bruyette by pointing out at the sentencing hearing on printed pages page 95 and 96 that Joe Bruyette's family love him. They like to think in their lifetime his parents will see him free, that they will see him out of prison. So the effort by Attorney Kershaw, the strategy he employed, was to show that Mr. Bruyette had the tools and the resources to have a chance of succeeding if the court had imposed a more rehabilitative sentence. That's clear from the, I see my time is expired. Thank you, Your Honors.
Thank you very much. How much time does the appellant have, please?
Appellant has 3 minutes and 29 seconds remaining.
Thank you, counsel.
Thank you, Your Honor. I'll first address the state's procedural arguments. The court should not look to federal law on 2255. The federal law was substantially amended in 1996, and this court has acknowledged that it threw federal law out of line with Vermont law, which is 13 VSA 7134. That is the language that we're talking about. And that statute says that a court is not required to consider a second or successive petition. This plainly gives the court discretion to consider whether or not a second or successive petition should go to merits. And this court has never said that claim preclusion is the same as section 7134. Claim preclusion, as I understand it, a court doesn't have discretion if it determines under a claim preclusion framework that a claim is precluded. The court can't typically say, I'm still going to decide it. But that is the case in PCR cases. And As for the adjudication on the merits, I think in Sanders, the U.S. Supreme Court defined the adjudication on the merits factor as being, it's either that the case was decided on the papers as being essentially meritless, or that it went to a full merits hearing. So the U.S. Supreme Court has defined what adjudication on the merits under the Sanders standard means, and that is different from adjudication on the merits in the claim preclusion context, which does include prior procedural dismissals. And that's, again, consistent with the language of 7134, that a court is authorized under Vermont law to exercise its own independent discretion to determine whether the ends of justice require addressing the merits. On the merits, the state referred to In re Williams and mentioned that there were multiple days in that PCR trial. There were also several claims in that PCR trial, so it wasn't a 12-day trial on this claim. But it also doesn't matter how much evidence was presented. This court has never required a particular quantum of evidence to prove an ineffective assistance of counsel claim. The assertion that we had to produce admissible evidence is inconsistent with the Vermont rules of evidence not applying at a sentencing hearing. So we didn't have to, Mr. Bruyette wasn't required to admit this evidence under the Vermont rules of evidence, even in his PCR proceeding, because that wouldn't have been required of him at a sentencing hearing. And finally, what the state highlights from the PSI is exactly the reason why it was so important in this case to conduct a full investigation into Mr. Bruyette's background, to present him in a humanizing light, because all of the court saw was the PSI that said he had this great upbringing, and then suddenly something happened and Mr. Bruyette can never be rehabilitated because of this horrible thing. Had his sentencing counsel presented him as a full person having had this very difficult background, there's certainly a reasonable probability that the outcome would have been different. Thank you.
Okay, thank you very much. Your time has expired. Please call a conclusion of that.
That concludes today's hearings.
Thank you both.